At Farah Farah, we also handle premises liability cases. This could be a situation involving someone who falls in a place of business or a store, or a situation involving negligent security, where someone is a victim of a criminal attack at a place of business or an apartment complex. When it comes to slip and fall cases, the landlord or the person that controls the property has the duty to maintain the premises in a reasonably safe condition. This is their responsibility. A lot of people come to our office wondering if they have a claim because they fell on a substance on the floor that was right there in front of them, or maybe they should have seen it. However, under the laws of the state of Florida, this does not stop you from bringing a claim. We all know that when you go shopping or in a place of business, you have an expectation that the premises and the floors will be safe from debris. The people who run these businesses don't want you to look at the floor. They want you to look at the products on the shelf. They want you to be in their place of business, so they have a responsibility to assure that the floors and walkways are well maintained. If you're injured as a result of a slip and fall accident, don't think it's your fault because there was something that maybe you should have done or should have seen. You may still have a claim. A lot of people who fall are embarrassed because people start running up to them and they can't determine what made them fall, and that can be an issue. This is something that you have to remember. If you're involved in a slip and fall situation, you need to be sure to try to determine what caused you to fall. You also want to obtain the contact information for any witnesses who may have seen you fall. You also want to note any statements made by the employees of the store. For instance, if the store employee runs up to you and says, "My manager told me to mop up the floor and I forgot to do it," that statement can be used later against the store owner to prove that he was at fault. If you have your cell phone with you, try to take a picture of the substance on the floor that made you fall, because this can be used as evidence later. If possible, try to determine where the substance came from. For instance, there may have been water leaking from a malfunctioning refrigeration unit. If you can show that the substance had been on the floor for an extended period of time, it indicates that the management of the store had ample opportunity to clean up the substance before you fell. Also, try to make sure that you get the employees' names and try to make sure that the store manager completes an accident report and that you receive a copy of it before you leave. Try to seek medical help immediately. Oftentimes, there's a defect in the property itself. Maybe the steps weren't up to code. Maybe there are structural problems with the premises that caused you to slip and fall. This is why it's important to find an attorney immediately so he can go out and take photographs and establish the defective nature of the property before the landlord tries to correct it. A lot of times, if they know someone has fallen, they try to fix the problem immediately. This is why it's important to go out, take photographs, and document the dangerous condition of the property before it is repaired by the landlord. Negligent security lawsuits are a fast-growing segment of litigation in the United States. In these cases, typically, the injured are seeking to hold the owner of commercial property liable for a violent crime that has occurred on the premises. Owners or possessors of property are required to take reasonable steps to make sure that their property is safe. Florida law states that when an owner has a duty to provide adequate security when there is a history of similar criminal activity on the property. Owners can be found liable for injuries resulting from criminal activity if they have received notice that a crime might occur. Landlords might violate this standard of care by failure to perform criminal background checks on employees, particularly those who have direct impact on the security of the property, its tenants or customers. Failure to properly screen new tenants. Failure to inform tenants about security problems or criminal activities near the property. Failure to establish or follow security policies or procedures. Failure to seek advice from law enforcement or independent consultants. Failure to provide or enhance patrols by security guards or other personnel. Failure to continue to review safety procedures such as lighting, fences, entrances, exits, and barrier systems, identification systems, closed-circuit TV, and other monitoring and alarm systems. Engaging in advertising that overstates security measures. If you have been injured as a result of a violent crime on a commercial piece of property, contact us for a free consultation of your claim.